Kenya has no Chief Justice or even an acting one for that matter, as the High Court in Meru has temporarily barred Philomena Mwilu from holding from holding her substantive office alongside a few others. Justice Patrick Jeremy Otieno ordered that a conservatory order is issued against Philomena Mwilu, restraining her continued occupation of the offices of a Deputy Chief Justice of the Republic of Kenya, Judge of the Supreme Court of Kenya, and member of the Judicial Service Commission, not forgetting Ombudsman of the Judiciary, pending the hearing and determination of the application. Now, the court has set the hearing for the 12th of February, and the petition has been filed by the Nairobi-based lawyer Isaiah Mbiti Mwongela. The move to bar Mwilu from sitting at the JSC stops her from participating in the process of picking the next Chief Justice. Further, the operations of the Supreme Court stand crippled because with Mwilu's absence and former CJ David Maraga out, the highest court lacks quorum. This move has elicited a lot of criticism, cynicism and politicization over the motive and procedural standing of the order. Let's sample some responses to the same. And the president of the Law Society of Kenya, Nelson Havi, says, and I quote him verbatim, "A judge cannot issue an injunction restraining another judge from acting." Besides, Justice Mrima dismissed a similar case. Only two explanations for this. He says Deep State has a lot of dirt on Justice P.J. Otieno and has banked a post-dated check given to it, or the order is a fraud. Let's hear what Ahmed Nasir Abdullahi has to say. He is a constitutional lawyer and senior counsel, and he says judicial orders must always be respected and given full faith and credit. But the order by Justice Otieno removing the acting CJ from office is ex facie evidence of gross misconduct and a willful premeditated act of judicial skullduggery and rather on the part of Justice Otieno. Mutula Kilonzo Jr., who is a senator serving for Makueni County, says, and he says, let me just make quick reference to what he says. He says the order is issued in ignorance of the law per incuriam, and kangaroo courts have some sense of law. Another tweet by Matthew Nyabena. He is the chair of the LSK Coast branch, and he says the order issued by Honorable P.J. Otieno is a coup against the Constitution. We have clear provisions on how to suspend a sitting judge. Making drastic orders ex parte casts doubt as to the motives of Judge Otieno. Does he have pending complaints himself? If yes, he should declare.